నమస్కారం. దూరదర్శన్ యాదగిరి ప్రాంతీయ వార్తా విభాగం సమర్పిస్తున్న భారతీయ నూతన నేర న్యాయ చట్టాలపై ప్రత్యేక చర్చా కార్యక్రమానికి స్వాగతం. బ్రిటిష్ కాలం నాటి చట్టాల స్థానంలో కేంద్ర ప్రభుత్వం తీసుకొచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 నేర న్యాయ చట్టాలు జూలై 1 నుంచి అమల్లోకి రాబోతున్నాయి. ఈ చట్టాలలో ప్రొక్లైమ్డ్ అఫెండర్స్ అంటే ప్రకటిత నేరస్తులు, ట్రయల్ ఇన్ ఆబ్సెన్షియా గైర్హాజరు కేసుల్లో ఎలాంటి నిబంధనలు పొందుపరిచారు, ఈ విషయాలపై మనతో మాట్లాడడానికి స్టూడియోలో ఉన్నారు సీనియర్ ఐపీఎస్ అధికారి, CDTI డైరెక్టర్ రాజశేఖర గారు. నమస్తే అండి.
నమస్తే.
భారతీయ నూతన నేర న్యాయ చట్టాల్లో ప్రొక్లైమ్డ్ అఫెండర్స్ ప్రకటిత నేరస్తులకు సంబంధించి ఎలాంటి అంశాలు పొందుపరిచారు?
In the existing system, if there are 2 accused, A and B, and A is present and B is proclaimed offender or B is absent, now either the case would have been stalled for wanting of the arrest of the B, or you split up the case between A and B and the case against A will run and the B will continue, but it will not, the trial would not have started and finally end in a dormant stage or a closed case, or as the court takes the decision. But now if that is not the case, trial on the proclaimed offender cannot be started till 90 days. First one. Second thing, the definition of the proclaimed offender under section 84(4) of the Bharatiya Nagarik Suraksha Samhita is that offences where more than 10 years of punishment, you can declare the accused as proclaimed offender, either he is absent from the trial or he is disturbing the court, that is suddenly and the court don't want his appearance, or the police could not arrest him. Now the case against A will continue, but for B there will be 90 days. In these 90 days there will be 2 notices issued with an interval of 30 days, and there will be newspaper or the local newspaper publication regard his attendance, his requirement is attendance in the trial. Third thing is friends and relatives will be intimated. Fourthly, after the 90 days, if he cannot be obtained or traced out, the trial would start, this proclaimed offender, and this includes absconder also. Now the court will appoint one lawyer from the district legal services authority who, in absence of the accused, that proclaimed offender or absconder, he will run the case, and this trial in absentia of the proclaimed offender runs from starting framing of the charges till the judgment. So person who has gone outside as a fugitive criminal, who evaded arrest, who evaded trial, now cannot simply sit that I am evading trial, the allegations against me will not be proved. That is not the case. The court will continue with the case material, the charge sheet, whatever it may be, and it can pronounce judgment and the sentence. Now the proclaimed offender who has been given sentence, now if he has to appeal in the higher forum, he has to physically present. That means to say that by sitting somewhere or evading arrest or evading trial, he cannot manage everything, because the state government is giving out of the DALSA financial implication, giving him the free legal aid as per the directive principles of state policy. So now the chances that the proclaimed offenders going out of the country or evading trial will not be suffer any sentence or this one, that will not be there, because this is victim centric laws, and there are a lot of provisions for the victim, and even during investigation the progress of the investigation has to be told to the victim within 90 days. This is the provision that has been there. As far as the other provisions of the proclaimed offender, for example, if they gone outside, then their photo, they have made some properties or some any of the evidences there in the outside. Now earlier what happened, you want to investigation abroad to bring him or for any of that case related material to be known. Earlier in the present system, the court will give the jurisdictional court will give the permission. Based on the permission, the IO will write to the SP or the CP, then it will go to the Interpol. From there it will go to the Minister of External Affairs, then it will go to the embassy, then it will go to our state, that is called as the assisting state, which has signed the Mutual Legal Assistance Treaty. Thereafter from the foreign police will conduct the investigation, and they will send the photographs or the videographs or whatever the case this one. But now it is simplified. The CP or the SP can directly do with this investigation, especially for the proclaimed offenders.
ఇక్కడ పోలీస్ అకౌంటబిలిటీ విషయంలో ఏదైనా సీజర్ సెర్చింగ్కి వెళ్ళినప్పుడు కూడా వీడియోగ్రఫీ కంపల్సరీ అని పెట్టారు.
Yes. Now the search and seizure, when the search and seizure on basis of search warrant, In those cases compulsory videography has to be there. Otherwise, earlier planting of the evidence by the police and they human rights violations, or they did not conduct a search properly, or they have added other things, or they did not conduct the search but they have made a search memo and they did not made some compulsion out of some public has input. These are the allegations made by the people, especially on the search and seizure this one. But now after when you take the search warrant, you go to the house, then first you have to do is the offer body search, because everything has been recorded, preferably by the mobile phone. After that one, you mentioned that there is a grounds of belief, grounds of reason for conducting the search in your case diaries. Accordingly, you made making the search, and in the search also the independent witness signature has to be clearly come in that videography. Secondly, the search and seizure has to be maintained and prepared in the place of search only. Thirdly, after the search is completed, the search document, seizure memo along with the, whatever this one has to be compulsorily forwarded to the court within 48 hours. There are multiple searches occurred simultaneously, then all will come in one place, and after that you can send it within 48 hours from the last search has been conducted. Under 165, now under 185 of the Bharatiya Nagarika Suraksha Sanhita, the searches are conducted by the police, by the IO or by subordinate officers. So there is a lot of accountability as far as search and seizure is concerned, and also the search and seizure video clip, there are chances that it will become a part and parcel of the final report, that is the charge sheet under 193. Actually final report is the correct word, charge sheet is one of the form of the final report. So that will become, that means to say that the accused or his counsel can have the searched video clip, the search video clip, and find if there is a loophole that has been happened in the search and seizure this one. So now the police cannot laxide on their part, they have to conduct search as per the rules and regulations. Though this gives accountability of the police towards the inmates of the house, and they cannot go and do whatever they want, or they cannot seize and later they show some other things. That cannot be done in these kind of cases now.
రైట్, గైర్హాజరు కేసుల విషయంలో అంటే ట్రయల్ ఇన్ అబ్సెన్షియా, ఈ విషయంలో ఈ కొత్త నేర న్యాయ చట్టాల్లో ఎలాంటి అంశాలు ఉన్నాయి?
Yes, trial in absence, as earlier told, if anybody is absent, either the case has been not started at all, or if it is joint with the other case, means there will be a split of the case and this one. Now the question comes, one who has supported the investigation, investigated, who has come with the police and they have cooperated with the investigation, and in trial he is getting the punishment. Whereas the person who has been a fugitive criminal or evaded arrest or evaded trial, he will not get this one. Only the absconder charge sheet could have been done, but the trial would not have been started because of the, we cannot frame the charges. Now you can frame the charges in absentia. That means the person is sitting outside, he cannot come, but you can show him in audio video means, and you can take the statement, you can frame the charges. And for example, if it does not come at all, it does not traceable at all, then what to do? The trial will start as if the other person is. Starting from framing of the charges and this one, and all thing will be done in absentia. The only thing is that the court has to provide one advocate out of the panel of advocates for fighting the case against him. So this is the one thing, because it is a principle of natural justice. So he will argue the case on behalf of the trial. This absentia, trial in absentia, can end up in judgment or till the last final sentencing also. Based on the sentence given, if you want to approach the high, can get, or whoever the claimants can get their property even during the investigation or the trial maybe. So the proclaimed offenders or the trial in absentia does not in any way come in between for the claimants to take their, or the victims to take their claims.
రైట్, జీరో ఎఫ్ఐఆర్ అండ్ ఈఎఫ్ఐఆర్, ఈ రెండు కూడా ఈ కొత్త నేర న్యాయ చట్టాల్లో వినిపిస్తున్న పదాలు, దీనికి సంబంధించి.
Yes, zero FIR was earlier also there, but not was on statutory. It was not there in the statutory point in the CRPC, but in the 173, section 173(1), irrespective of area, says that zero FIR. Zero FIR means you are submitting the complaint beyond your police station jurisdiction. You are going to another state or another district, but the crime happened in your district. Then you need not to come to the same place where the crime happened or the same jurisdictional police station. You can file any complaint at any place. That is called as zero FIR. EFIR means now you need not to go to any police station physically at all. Go to the police station or the district police website and you register a complaint. Now of course there is a 100 dial and all those things which are almost equal to a telephonic call complaint also. Now in the zero FIR, if the other police station received a complaint, they have to make entries in their GD and produce or forward that complaint to the concerned police station jurisdiction. In EFIR, the copy has to be signed, the complaint has to be signed within 72 days and it has to be sent to the original jurisdictional police station. But in any way, it doesn't bar the police to start an investigation if a cognizable offense has been made out. That means waiting for the signed copy is not compulsory and registration is not compulsory, as we know, because in some murder cases investigation starts even before the registration of the FIR. So this is a more citizen centric approach, we can say. Now with online everything, they need not to come to the police station at all and put up their complaints either online or wherever they go. This is the another provision that has been this one zero FIR and the EFIR. And the preliminary inquiry. Now earlier in the section 154, when the complaint has been or the FIR, there was no concept of preliminary inquiry. But the Lalita Kumari judgment say that preliminary inquiry should be conducted in the cases where there is no where is a vague or doubt whether a cognizable offense has been made out, vagueness. So in those cases, whether a cognizable offense is made out or not, you first register a preliminary inquiry, take 14 days time, which was not there, that time period was not there, and you thereafter you decide whether to register a regular case or dispose of the case. So this zero FIR, EFIR and the preliminary inquiry under the section 173 is a highly citizen centric and it helps the people to register maximum number of cases, because in cyber crime cases already we have section free toll number called 1930 or National Cyber Crime Portal, where you can register the online complaints, and if you have defrauded the amount, that fraudster, that amount will be freezed from him, so that you will get back the amount as soon as possible. So added with these things, now every crime is involved with cyber in one way or the other. It is a very good provision that is zero FIR and the EFIR has come into the picture.
ఎలక్ట్రానిక్ ఆధారాలు, ఈ ఆధారాలు, ఈమెయిల్స్ అండ్ ఎలక్ట్రానిక్ ఆధారాలకు కూడా ఇతర ఆధారాలతో సమాన హోదా కల్పించారు.
Yes, see, in the definition of documents, electronic and digital records are also included as documents. And secondly, in section 57 of the Bharatiya Saksha Adhiniyam, there are 4 new definitions or explanations which constitutes primary evidence. Primary evidence means where the original evidence has been taken to the court. Secondary evidence means where the original could not be taken to the court. For example, CCTV camera, the internet connection, that is the web or whatever it is, server in the banks, it cannot be taken to the court when some fraud happen in this one. In those cases, you take a clip or a folder or some dump and take into the court. That is called as secondary evidence. So now the electronic and digital records, and section 530 of the Bharatiya Nagarik Suraksha Sanhita tells about in all what cases can be done in audio video. Search, audio video, you can search warrant, you can take in electronically, you can conduct the videography of the search and produce it. You take the statement of the witness via audio video, means person accused in jail, you take this one, you file the charge sheet via e-filing. Like this, everything has been made electronic and digitally viable, because earlier in the cases, many cases have been caught, like Navjot case, PK Anwar versus PV Bashir case, and third is the Shafi Ahmad versus state of Himachal Pradesh, and thereafter the Arjun Pandit versus Kailash Rao case. Courts have been deferred whether the 65B certificate, the electronic records, appreciable or not, and all those things, and also what time they have to be produced. Now it is clear electronic and digitals are part and parcel, and they are as good as the documents.
Right, thank you sir. ప్రకటిత నేరస్తుల విషయంలో గైర్హాజరు కేసుల విషయంలో తీసుకున్న నిర్ణయాల గురించి చాలా చక్కగా వివరించారు. థ్యాంక్ యూ సార్.
నమస్కారం.
కేంద్ర ప్రభుత్వం తీసుకొచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు, భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాలు జూలై 1 నుంచి అమల్లోకి రాబోతున్నాయి. ఈ చట్టాలలో ప్రకటిత నేరస్తుల విషయంలో, గైర్హాజరు కేసుల విషయంలో తీసుకున్న పలు కీలక నిర్ణయాల గురించి తెలుసుకున్నాం. నూతన నేర న్యాయ చట్టాల్లోని మరొక అంశంతో మళ్ళీ కలుద్దాం. నమస్కారం.